What you're about to watch here isn't a technical dispute buried in legal jargon. It's a warning about how quietly and easily the rules meant to protect your privacy can be rewritten without your consent, without transparency, and without accountability. In this hearing, Congresswoman Pramila Jayapal zeroed in on something most Americans would never notice.
Thank you, Mr. Chairman. Thank you for holding this hearing, and thank you to the group of us on both sides of the aisle that have been very consistent on this and have taken on our own party in power. It does seem like it gets very difficult. People change their views based on who's in power. And so I appreciate the work we've done on a bipartisan basis to really protect the privacy of Americans and make sure that we're upholding our constitutional obligations. I want to go back to this question of queries, Ms. Goitein, because you talked about it quite a bit in your opening statement. And I think that these preliminary numbers are not really, we just have no idea what they really show. And so I want to talk a little bit more about why we need to approach that current number that's been given to us with caution, and also ask you, because this is a clear example of how the FBI just changed the rules and they're not complying. How do we make sure that whatever we write into law, it appears now we have to define query, but what ideas do you have for when we approach this again, that we are actually ensuring compliance with our intent?
Well, Congress did define query, and I have kind of racked my brain to try to figure out why somebody at the FBI decided that these were not queries. This was a system that allowed FBI agents to retrieve communications associated with a particular case file or facility, which is basically the communications of a particular target. Mm-hmm. But it also allowed them to search for particular participants and pull up those participants' communications, and those could include U.S. persons. So it was basically a way to run queries on a subset of Section 702 data, and the query could be for a U.S. person's communications within that pool. It's hard for me to understand why they didn't consider this to be a query. One possibility is that there was a drop-down menu involved, and the definition includes the use of one or more terms to retrieve the unminimized content. So maybe if you're clicking on a U.S. person's account rather than typing it in, maybe that's not being counted as a query. I don't know this for sure. I'm just trying to understand. Mm-hmm. One of the things that also puzzles me is that apparently the National Security Division just happened to find out about this in August of 2024, and the practice wasn't suspended until early 2025. Why did it take that long to look at the definition, look at what was happening?
Well, that's right, and it seems to me, Mr. Chairman, that we might be able to do, some sort of our own inquiry into this right away, and at least get the correct numbers and make sure that we are operating with full data. I want to ask you, Ms. Goitein, also about the question of 702 does not allow for the targeting of U.S. persons, and yet millions of Americans have been targeted for surveillance under this statute. Why is it important to protect everyone in the United States from warrantless surveillance? Does include persons, American citizens, and all persons in the United States?
Yeah, I mean, first of all, as a constitutional matter, the Fourth Amendment protects everybody in this country. And so if you believe that a warrant requirement is a constitutional requirement, as a district court held a year ago, as a unanimous panel of the Second Circuit seemed to indicate in their earlier decision, then it applies to everyone in this country. But there are practical reasons as well. Just as collection of the communications of non-U.S. persons incidentally pulls in U.S. person communications, queries, any query can incidentally retrieve the communications of Americans. And that's because, even if you're querying a non-U.S. person inside this country and pulling up the communication they have with a non-U.S. person target, those communications can have other people involved in them. It can be a group email or a group text that includes any number of U.S. persons. If the non-U.S. person being queried is in this country, that vastly increases the chances that they are going to be in frequent communication with Americans in this country. And so these are queries that pose particular risks to Americans.
We have been hit with lots of opposition arguments, and so I want to give you one and ask you to refute it. Some people view the apparent decrease in backdoor searches with some alarm and ask whether the FBI is not making queries that it should be making. How would enacting a warrant requirement both protect Fourth Amendment rights while providing a clear process for the FBI to do its work. This was just something raised all the time to us.
Yeah, well, if it is in fact the case that FBI agents are not performing legitimate queries because they are, there's too many layers of oversight, or they're worried that they will be penalized if somebody later decides that they shouldn't have made the query, there's really a simple answer to that. I mean, needless to say, the answer is not to get rid of the oversight and go back to all of the queries of congresspersons and protesters and all of that. The answer is to have the government get a warrant to put the burden of gatekeeping these searches where it belongs, which is with the courts. That would reduce the need for all of these layers of internal oversight and whatever sort of administrative paperwork and burden is associated with those layers. And it would also remove any motive that might exist for FBI agents to be excessively cautious. FBI agents would be free to do their job, to vigorously pursue investigations within the law and their professional obligations. And then the courts could do their job, the job that they do in pretty much every context except 702, which is determine whether there is a lawful basis for this.
Thank you, Mr. Chairman. I hope we can work together on actually getting compliance with the real numbers around the queries. Thank you. Yield back.
The tried and
Unless someone slowed it down and explained it. The FBI didn't just bend the rules around surveillance, it changed the definition of the rules themselves. At the center of this exchange is Section 702 of the Foreign Intelligence Surveillance Act. It's a powerful surveillance authority designed to target non-U.S. persons located outside the United States for national security purposes. On paper, it does not allow the targeting of Americans. That's the promise. That's the safeguard. That's what Congress was told. But Jayapal made clear that what's happening in practice is very different. She focused on something called queries, searches conducted by the FBI through massive databases of communications collected under Section 702. These databases inevitably contain Americans' emails, texts, and phone records because Americans communicate with people overseas all the time. The law tries to limit abuse by requiring strict reporting and oversight when agents search for U.S. person information. Here's the problem Jayapal exposed. The FBI appears to have reclassified certain searches, so they no longer count as queries at all. Not because Congress changed the law, not because the courts approved it, but because the FBI decided, internally, to interpret the word differently. According to the expert testimony, FBI agents could retrieve communications tied to a case file, pull up participants in those communications, and access U.S. persons' data without counting those actions as queries. In other words, Americans' private communications could be accessed while technically dodging the safeguards Congress put in place. That's not a loophole Congress intended. That's an end run around the law. Jayapal pressed even harder when it became clear that this practice wasn't immediately disclosed. The FBI's National Security Division reportedly didn't discover the issue until August of 2024, and even then, the practice wasn't suspended until early 2025. That delay matters because every month that passed meant more surveillance without proper oversight, more uncertainty about how many Americans were affected, and more erosion of trust. If you're communicating with someone overseas, or part of a group chat, an email chain, or a workplace message that includes someone who is, you can be swept into this system. The expert explained that even queries targeting non-U.S. persons can easily pull in Americans' communications incidentally. And when those searches happen without warrants, the Fourth Amendment is no longer doing the job it was designed to do. Jayapal made an important point that often gets lost in these debates. The Constitution protects everyone in the United States, not just citizens, not just people the government likes. Everyone. The Fourth Amendment doesn't disappear because the FBI finds it inconvenient. Supporters of expansive surveillance often argue that requiring warrants would slow investigations or make agents afraid to act. Jayapal confronted that argument head-on, and the response was devastatingly simple. The solution to fear and confusion is not less oversight, it's clearer rules. A warrant requirement doesn't stop investigations, it shifts responsibility where it belongs, To the courts. Judges already do this work every day in nearly every other area of law enforcement. Requiring a warrant would protect civil liberties, give agents legal clarity, and eliminate the incentive to quietly redefine terms behind closed doors. This wasn't an anti-FBI argument, it was a pro-democracy one. Jayapal wasn't accusing agents of bad faith, she was calling out a system that allows agencies to police themselves, while Congress is left guessing whether the numbers it receives are real, complete, or intentionally understated. And that's the real takeaway from this exchange. The danger isn't just surveillance. The danger is normalization, accepting that agencies can reinterpret laws without telling the public, delay disclosure without consequence, and treat constitutional protections as optional guidelines instead of binding limits. Oversight only works if lawmakers insist on real numbers, real definitions, and real compliance. If this breakdown helped you understand what's actually at stake when surveillance laws are debated, support the channel by liking the video, subscribing, and sharing it with others who care about privacy, constitutional rights, and government accountability. Stay informed, stay engaged, because once privacy is lost quietly, it's almost impossible to get back.